All right, so now we will start with our What's New category. And for most of you who have been to the quarterly or proficiency trainings that we've held, the What's New section I use is there to try to communicate some various pieces of information that have come up since the last time we have met. Some of this information, especially if it was very important when it was released, has been sent out via email, or in some cases fax or mail to you already. So you may be seeing this a second or third time, but again, this is some of the more key information that was released, and for this, since October, essentially when we last met, up to the end of the year. So I've picked out some key topics for us to cover on that. So those of you who have the handout that I had sent out via the email, and it's attached to this webinar for the What's New, you can look at that. Also, I have placed that up here for viewing as we cover it, in case you did not receive that handout earlier. The first item, and that comes courtesy of Mr. Roger Harrell from DVA Claims Office, is the best guess dates. And our best guess dates were as of December 4th. He is currently working on a new one, but that information was not readily available as of today. So we'll be going off of what we had as of December. Again, this should have already been sent out in December, and so many of you are probably seeing it for a second or third time. But just want to make you aware of these dates. The biggest change to the best guess dates has been on the BVA docket, and that BVA docket has moved up to October 12, 2012. Additionally, addressing CRDP and CRSC has moved to October of 2014. Hopefully when we receive updated information in January here, that'll move a little bit more, and hopefully it's up to November or December, which means we're closing on most of that backlog going away. Unfortunately, dependency, 686Cs, that's still backlog in September of 2013. Again, those who are submitting the dependency claims electronically via e-benefits, those, as long as they can be handled automated-wise, those are getting turned around real quick, generally within anywhere from 24 hours to roughly 3 to 4 days. So if you have that opportunity for that to be submitted through e-benefits for your veteran, that's the best way for that to happen. Anything coming in, the paper-wise, is going to be caught up in that backlog. All right. Another piece of information, again, many of you should be aware of. We touched on this back in November with an email with a update, and this is in regards to service members and veterans that were possibly exposed to warfare agents such as mustard agents or sarin during Operation Iraqi Freedom. The VA is now attempting to get in contact, or has been as well, attempting to get in contact with these individuals to address any health concerns. If you have a veteran or service member that comes into your office that expresses concern that they may have been exposed to one of these, the hotline number is listed here for them to get in touch and get an exam scheduled. All right. Moving down a little bit further, I'd like to talk about the pension side of the house, specifically the Pension Management Center in Milwaukee. During our quarterly VSO call with the Pension Management Center in December, we received some updated information regarding the processing of pension claims, their integration with VBMS, that schedule and so forth, and some other things that they've been experiencing that tend to add to certain delays as well. I've included a lot of those highlights here in this What's New section. On the chart that you can see here for FDC, fully developed claims, on the pension side, key things to just note here. If you look in this column of ADP, that is average days pending, that gives you an idea of the type of claim and the average days pending on that specific type of claim. The last column, ADC, FYTD, is average days to completion, fiscal year to date. That gives you their overall average of completing that claim, making a decision on it, as of the 11/29/2014. The good news, 60% of the claims related to pension arriving at the Pension Management Center are fully developed claims. That's a great increase from what it's been over the first part of 2014 and the end of 2013. So that is great because it obviously helps to keep that average days pending and average days completion down. Overall, as you can see in here, a fully developed pension claim, they've been looking at about 49 days to process it. One of the key things to note that and many of you may have heard this, the Pension Management Center has been brokering in, and as of this VSO call in December, we'll still continue to do it through March of 2015. They're brokering in claims from the Philadelphia Pension Management Center. They've been averaging about 800 pension claims per month. Now, that does have some impact, obviously, in doing those. Fortunately, according to the Pension Management Center, they've been able to minimize a lot of the delays in the impact that it's had, and hopefully this brokering in will trickle down before March. If not, hopefully it will be completed in March. Another key thing, Pension Management Center is still saying they wait anywhere from 10 to 16 days for the IRS or Social Security to respond to their electronic request for income verification matching. So obviously that 10 to 16 days, you need to take that in consideration of their average days processing. So some of these things are not totally within their control, just as something to make note of, and adds to that overall processing time. Another key thing they've asked for is when sending in the pension claims, please try to send in a certified stamped copy of discharge paperwork. They are stating that this helps them drastically in their PIES request backlog, because if it's not verified as a true copy of the original document by stamping it and certifying it as a accredited representative who has gone through that certification of documents class, then what the VA has to do is they have to verify service. They have to treat that as not a verified copy, and they have to go out and do what they call a Personnel Information Exchange System request, or PIES, and that can add up to 2 weeks in backlog time for processing. So if they have that already stamped and certified that we have verified this is a true copy, they can proceed forward and not have to go into that backlog. Another key thing, Pension Management Center has 7 new VSRs They're actually trainees. They'll be added to the rating team once they complete their training. And they are in the process, and actually probably are completed now because they were anticipating by the end of December having 3 additional DROs, decision review officers, hired to deal with the notice of disagreements and appeals process on the pension side. One key thing here, pension management centers. For all of you out there who are aware of VBMS, and most of you should have heard that term, Veterans Benefit Management System, already, and the push to getting into a purely paperless environment, per se, with the VA for claims processing. The pension management centers are not yet integrated with VBMS, and they're actually in the process of doing that. So unlike compensation side of the house, where the development process and everything is focused now with the use of VBMS, pension management centers are still utilizing MAPD and still utilizing virtual VA very heavily in their development process in managing claims. So as a result, one of the key things here is that virtual VA fax, and we've covered this in a couple previous proficiency training sessions. And the virtual VA fax actually allows you to fax your claim electronically into virtual VA. Obviously, it's accepted, it's getting date stamped, and then it allows the pension management center to assign and start working that, essentially keeping it paperless and making it a quicker delivery as well. That is the key way, the preferred way, I should say, that they would like the claims to be sent to them. Obviously, in some cases that can't happen, and so direct mail is the other option. They caution against having the claims routed through your VA regional office, and the reason for that is VA regional offices are, again, focused on VBMS. They are focused on scam centers, and now, which is up and coming, the central mail facility. So everything is geared towards getting that scanned and going to the scam center and sent in. Therefore, what that does is the regional offices tend to route that through the scam center, and it delays getting to the pension management centers again. And that delay can happen anywhere from a few days to 2 or 3 weeks. So pension management centers are strongly discouraging routing your mail through your regional office for pension claims. Another key item, and some of you have emailed me about this throughout 2014, and that has been on automated burial process. There has, some of you have experienced the actual success of that automated process where the veteran has done first notification of death. And from that point forward, the burial benefits have been processed, sent to the spouse. If appropriate, a DIC claim has been initiated, and that has been processed. And that is the goal of the Pension Management Center and the VA in those situations, is to have that automated process work for survivor benefits. And there's a way that you can kind of track that if you're looking in SHARE, the VA system, and you can look under certain end product codes, or called EP codes, and you can tell how that processing is happening. So if something is coded at 299, it means that automated month of death payment has been set up. And then you can see the other ones that I have listed there for burial payment and DIC payment. One key thing the Pension Management Centers did bring up in December is, and this has to do with the VA's whole process of workload distribution amongst the entire VA system, as opposed to just compensation. And that is, they have been working compensation claims on a limited basis, not just pension claims. They've actually brokered in claims directly from the Milwaukee regional office, as well as a couple others, one of them being in Houston and Waco, Texas. And they've been working compensation claims from those specific areas in a kind of a pilot test program, but also to reduce workload there. So they wanted to make everyone aware of that, especially as we know veterans get those letters and all of a sudden they see it from a different regional office or something else, and they want to know why it's being worked in there. Also noted that as a result of the COLA for 2014 that went into effect, they had about 16,000 cost of living adjustment messages, pension related, were sent out, and these are all related because pensioners had received obviously an increase to your Social Security. That 1.7 applied to Social Security as well as VA benefits. So that roughly about 16,000 is who they sent that out to. So you may have some of your veterans that are on pension that have contacted you and said, hey, they got this notification about their Social Security going up. Now, in most cases, that may not be enough to offset their pension, but in some cases it could be borderline and it could offset their pension. Also in here, just for general questions, call center information number and VSO telephone number, as well as email. So if you have questions related to pension, again, related to pension, you can utilize this, one of these numbers or the email to submit that question. One of the key things under reminders, Pension Management Center has asked, if you utilize virtual VA fax, please do not mail the hard copy claim that you have faxed in via virtual VA fax. What that does is it causes a confusion initially when they receive that hard claim and begin to set that in or process it, and there's already one pending in virtual VA. So if you successfully send it in via virtual VA, do not mail the hard copy to the Pension Management Center. Now, the virtual VA as well, once it has been assessed in, you'll be able to see that those documents that are related to that claim are in virtual VA. So if you have access to virtual VA fax, you'll be able to verify by being logged in and seeing that those documents are there in that Veterans e-folder. All right, next item. The 2015 pension rate chart. Hopefully all of you found that in the that attachment in the email I sent out prior to holidays, and that is with the new rates that reflect the cost of living adjustment for pension. And again, that was in an Excel spreadsheet that I sent out to everyone. That is also a PDF. Now those rates, just as a quick, I won't go through every one of them, but just as a quick highlight, veteran alone, you're looking at that move to $12,868 as far as the income threshold. 5% medical moved up to $643. So everything in excess of $643 for unreimbursed medical expenses would be able to come off that income, accountable income for that veteran. For the survivor or widow, that increased to $8,630 for just the widow. If you have one dependent on there, it moved up to $11,296. DIC also increased to $1,254.19. Please remember, compensation Still the same issue here. The rounding law expired last year, so actually end of 2013. And so through all of 2014, we had those cents attached to everything related to compensation. DIC falls in that category, and the same for beginning here of 2015. That rounding law has not been reinstated by Congress, so we still are seeing the cents down to the pennies there for compensation related. Veterans Choice Card. So for many of you have probably either received yours, if you're in one of these categories, or you've had veterans contact you regarding the Veterans Choice Card. I know I've received a few emails out from the field that have indicated they've had veterans come in saying that they've received the card, but yet they went to use it and they were told they were not eligible to use it. In some cases they were told you're not even in the system. Various types of responses that basically said, no, this card cannot be utilized by you. The Veterans Choice Card or Veterans Choice Act is, one, a limited act. Again, it applies in strict eligibility criteria, and that eligibility criteria is not always clear to everyone out there. And with any program the VA releases, initially on the front side, there's always going to be bumps with this to get things smoothed out. Primarily, they release these cards in 3 phases. The phase 1, accordingly, for those who were in the VA healthcare system and they lived more than 40 miles from a VA medical facility. They were the first phase that got sent out. The second phase was for those who were enrolled in the VA healthcare system and they were waiting for a medical appointment, longer than 30 days from their preferred date or from a date that was deemed medically necessary by their healthcare provider. And then phase 3 was all other veterans enrolled in the VA healthcare system that may be eligible to use this program at a future date. They were the last phase that received this. Now, one of the key things that I've received from the field is regarding the 40-mile radius. I've had a couple emails that said the response given to an inquiry was they're measuring that 40 miles in nautical miles. I cannot attest to that being accurate because I've seen nowhere where that is saying nautical miles. That would not make sense to me. Not saying that's not what the response was, but what I have been able to verify is the 40-mile radius they are using from a VA medical facility is from their residence, and it is the shortest distance. So if there is more than one route from the veteran's house to a VA medical facility, it's the route that is the shortest distance that they measure that from. So one route could be 39 miles, another route could be 42 miles. It's the 39-mile route that the VA is going to measure from, and thereby that would make them under 40 miles and not eligible to use that card. So I do want to stress that it's looking at all routes to that facility from their house. And if one of those routes is 39 miles or under 40 miles, that's the route the VA is going to use. It's the shortest route. No matter if it takes them an hour to get there versus the other one that's longer, takes a half an hour, it's the shortest route they're going to measure from. So that can be part of the problem with some of these, that you may be taking interstate and considering that route because that's the quicker way there, and that's the one that's longer, but it may be secondary roads that are shorter, and that's the one they're measuring by. So that is one instance that I've been able to find as far as the mileage goes. Another key thing with this program is remember that this program is limited. It is a program that is set up for 3 years. It is not a permanent program yet. It is different from fee basis. It is not the same as fee based. It is not the same as the other pilot program for rural residential care, the ARCH program. This is a very tailored program to deal with essentially backlog in scheduling appointments overall and getting health care out there quicker. But there are some stringent requirements for it. Additionally, that 3 years is while funding is there. So if it's 2 years from now and the funding is exhausted and not reinstated, then the program will go away in 2 years versus 3 years. So please keep that in mind as well. And one other question that was just asked here was on the CBOX or just VA hospitals. Again, the specific thing here is a VA medical facility. So if the CBOC is run by the VA, yes, that counts. If it's not, then they are counting against a VA medical center facility that's run by the VA. Again, I think that is one that is still in contention that I know from at least the VFW side, they've been addressing that further with the Secretary of VA as well. Another key thing here is enrollment. The veteran must have been enrolled in VA healthcare system, whether they've been enrolled due to a service-connected disability or they're enrolled because they meet the income requirements, or they're a pensioner, and obviously can get enrolled. They have to have been enrolled in the VA healthcare system by August 1st, 2014 to be eligible to use this choice card. So if they were not enrolled by that date, that can also be another reason why they are told they're not eligible to use this card. Now, it would stand to reason they don't get sent that card if that was the case, but obviously we know those things happen and they still get sent that card. So again, that's a key date to look at. Additionally, you'll notice that there is a number on that card. That number is for them to call to determine eligibility for use of it and to schedule an appointment if they're eligible. VA has contracted with 2 vendors, TriWest and HealthNet, to actually help manage this program. And they are the ones primarily that are going to be involved with determining the eligibility based on the criteria set up by the VA, and if eligible, then taking care of the scheduling of the appointment. So it is important that your veteran knows to call that number to determine eligibility first, and then schedule their appointment via that number. Otherwise, if they just choose to go to one of their doctors near their house and they want to try to get care and they try to use that card, they're going to find out they're going to get stuck with the cost of that care because they haven't been turned eligible. Additionally, for the use of a private care facility or doctor, the veteran can request to use a specific doctor if they're eligible. Again, they will have to verify the VA is contracted with this provider, with this doctor. And bottom line in that contracting process is the provider has to agree to either accept Medicare rates, or they have to be working with a Department of Defense facility or in one of the Indian Health Service facilities or other federally qualified health centers. The key point of that is they've got to be in agreement to these specific rates set. And if they're not, they're not going to be able to establish that contract with the VA. And so then that provider may not be the one that your veteran will be able to see. It may have to be someone else who's agreed under those terms. So again, another key point to keep in mind. Now, I see another question again on the miles up there. And again, versus the nautical, they're using air miles. If they are using nautical miles, from what I've been able to verify, it is land mile, base miles, routing miles, and it is based on the shortest distance from any route to a VA facility. I have not been able to verify that they are using nautical miles, air miles, or anything of that nature yet. I still have a question in regarding that to the VA, but what I've been able to verify so far, it is the shortest route possible from their residence to a VA facility. One last thing to keep in mind with this choice card is, again, VA is a second payer when there is other insurance involved. When Medicare is involved or another health insurer is involved, such as the veteran being covered under another health insurance plan, such as the spouse's plan. So if that's the case and the choice card is used for non-service connected care, notice I'm saying non-service connected care, and the choice card is used and the veteran has other health insurance, then what's going to happen is that other health insurance is going to be the primary payer and VA will be the secondary payer. In other words, they'll be responsible for any co-pays up front, and their health insurance will get billed first. And then, after, the choice card will come into play and pay. So that, again, is another key point, that there may be out-of-pocket expenses still coming with this veteran if there is other health insurance involved. And, again, it being specifically a non-service connected reason they are seeing this provider. That is also, when I say other health care too, keep in mind that does also involve TRICARE. All right. Next item I'd like to cover is reconsideration of a denied claim for disability compensation. The reconsideration has kind of caused a lot of confusion, a lot of uncertainty back and forth, and especially since reconsideration essentially for the process of a decision, an award decision on a claim from the RO's perspective, not from the BVA side of the house, is something that is not standard at all VA regional offices. Each regional office has its own policy on how they address reconsideration, or if they're even going to address a reconsideration, or if they're just going to say, hey, it has to be based on a notice of disagreement or a reopened claim. Reconsideration is essentially, too, a reopened claim. However, you're preserving that effective date, essentially, with it. So bottom line here is when you're asking for a reconsideration, the regional office here in Nashville has asked for this process to be followed, as I've put out here on this document. They've asked for that reconsideration to be done on a 526 EZ, same as we're using for all fully developed claims. and utilizing a 4138. And the 4138 is used to give details about the reconsideration you're asking. I've included a little statement to be used as far as making that request, and I've sent out a couple examples, or an example of the 526EZ filling it out, and of the 4138. On the 526EZ, and I will enlarge that, you should be able to see that now. And I've used our famous veteran here, Donald Duck. We're taking just two issues, and prostate cancer and ischemic heart disease. Both, in this example, both of these were denied by the regional office. And so we've asked for a reconsideration on both of these issues, because when we looked at the rating decision narrative and the reason for denial, and gone back through what was submitted for evidence, and medical evidence specifically, we have seen that it looks like they did not consider certain evidence. So in that case where you've identified that it looks like they have not considered certain evidence, or considered it properly, per se, given it perhaps the appropriate weighting in the decision, you can ask for that reconsideration. And if the evidence of record is not private, it's all federal through VA, you can list, just like we do, VA Medical Center, National Campus, Nashville, Tennessee. If there is private medical evidence and it was submitted with the original claim and is still of record, you don't need to resubmit that evidence. You can simply state that evidence that was submitted on the 4138 and state that you believe it was not properly weighted or was overlooked overall, but you're making it known this is part of the reason why you're asking for a reconsideration. Again, with the 526EZ, making sure all of the blocks are filled out. And I stress this on this example as well as anything dealing with just submitting an original claim or supplemental claim under the fully developed claim process, because as we do get the opportunity to move forward with submitting claims completely electronically through Vetrospect and ultimately to the VA and the D2D system, it's important that all of these blocks be filled out. If they're not, it will, at this point that we've seen so far in our testing, it will cause an error in the claim submission, and then we have to go back and correct it and resubmit it. That's to include even the direct deposit information or the banking account information. Many of us are in the habit of writing in of record when you get down here to account number, or you get down here to financial institution or routing number. We put in there of record or on record or on file. When we're going back to submitting this fully electronically, this information has got to be filled out. If not, it will cause an error in kicking it back, and it'll have to be corrected. I know some of you are probably going, okay, well, you know, if I haven't helped this veteran before, then I'm not going to have that information, right? You're going to have to ask them that information and make sure you have it. Another way to verify, too, what that information is through shares, through the VA share system. You'll be able to see what their current banking institution is, what that routing and account number is as well. And then coming in again with the veteran signing it, or in the case of this being a reconsideration, the veteran service representative can also sign. Now the 4138, which is going to be used to provide detail, that's where you get into making your statement, request reconsideration, and in this example of the December 4, 2014 rating decision, you state that all up front, and then you put in here evidence to support this request is as follows. And here's where you can restate what the evidence of record already is and that perhaps was not considered or overlooked or not, you believe was not assigned appropriate weight in the decision process. If there is some additional evidence that has come to the veteran since the claim was submitted, you can submit it along with this as additional evidence that may impact the changes. The key thing here in the reconsideration that I want everyone to remember is this. The regional office, if they agree to look at this as a reconsideration, essentially does not have a defined time limit. It could take them 30 days, it could take them 14 months. What you have to remember here is if it's going to take them longer than 12 months from the date of decision, you need to make sure that your veterans' appeal rights are protected and file that NOD before that year time limit is up. Otherwise, you will have to deal with a reopening, and then you will lose that effective date of claim. So a reconsideration can be helpful, especially if the evidence seems very compelling that it was just overlooked. But you've got to bear in mind, you've got to track that timeline, because if the regional office is not moving forward with addressing it, and now you're coming up on that year timeline, you want to protect that veteran's appeal rights and get an NOD filed. So key thing to keep in mind with this reconsideration. Additionally, the regional office can come to us and say, hey, we want you to change how you're doing the reconsideration. So we no longer want it this way, we want it this way. So what I'm covering here today, I just want to stress to you, is subject to change at any point in time, especially as D2D comes online and is able to accept more than just original claims in that process. So things may change as far as filling that 5260G out, or what has to be included on a 4138, and so forth. So this is not written in stone. Right now, this is the process they would like us to use, but again, this could change at any point in time. One other I see I've got a couple other questions that have come in here. We're going to, at a stopping point here for our What's New, so we're going to take just about 5 minutes. I'm going to look at these few other questions here so that we can address them before we move into our next category. So we have right now about 9:35. At 9:40, I'd like everybody to be back on with us. Now, you don't have to sign off. You don't have to do anything from your end. What I'm going to do here is you'll just see the video go blank for a moment, and my mic will be muted. But then at 9:40, I'll be back live on here. So this will also give you just a brief moment, too, to use the facilities or get a drink of coffee or water if you need. looked at a couple questions during the short break, and one of the things regarding the driving distance for the choice card, I want to thank Mike Scott out there. He faxed in a VA fact sheet that he had that I had not seen yet. However, it's interesting because the one he sent me conflicts the other VA fact sheet that I have on the summary of the program as well, and that is dealing with the driving distance. The sheet he has sent it to me, it addresses the driving distance that it will be calculated based on a straight line distance rather than driving distance. So essentially a straight line from the veteran's residence to the VA medical facility is how they're calculating it, opposed to the other FAQ that I mentioned earlier, and that is the shortest available driving route. So there is still some conflicting information there between the two VA, and both of these are put out by public contact from the VA side of the house as well. So again, I'll still need to pursue the question I have at hand to deconflict this information. But what Mike has sent in is stating that it will be a straight line distance rather than driving distance. And additionally, as the VA has mentioned in a couple other press releases, they are developing a dashboard tool similar to the education side of the house as well that will allow the veteran to go in and determine their distance for the use of the Veterans Choice Card right on the VA.gov website. It will be a dashboard utility tool. This is indicated November for it to be ready. I have not seen it ready yet, or I know there is a preliminary version ready, but I haven't seen it fully released yet. But thanks again, Mike, for sending that additional information, and I will continue to run that conflicting information between those two FAQs from the VA down and send it out to the field once I get that deconflicted. All right. Also had a few pieces of information that were sent to me via the chat box from some of you who have done a reconsideration, where you have found that submitting evidence in a chronological order of when these complaints were made has helped to deconflict whether that evidence has been considered or not. And again, good point. Key thing for the reconsideration, as I want to bring back around, is if you're going to do it, please make sure you are tracking the time limit here. And if you're in VetraSpec, you can set up a My Task reminder for your veteran so it helps you track that and you see it each day when you're in VetraSpec. You can do it through Outlook. There are many ways of doing it. I just stress that you do track that time so that you don't lose sight of it and your veteran doesn't end up suffering from not being able to exercise their appeal rights if that reconsideration is not done within that year time limit from the decision. All right. Another topic I'd like to update everybody on, and once we cover this, I will do, again, another short little break just for everyone to stretch, and then we'll be finishing up with unreimbursed medical expenses and income reporting as our last two topics. But this next topic is D2D. We've already kind of alluded to it during some of the what's new information that I've covered. And what's been happening with D2D since we last talked during SOPs. As officially, D2D has gone live, and you should be seeing, bear with me just a minute here. should be seeing this up on your screens now. D2D has gone live. It's gone live in a very limited way, though, currently. It is live for us to continue to test, but we are actually submitting current claims, original claims, through the D2D gateway that meet the criteria to be accepted electronically. This initially happened in the fourth quarter of FY 2014, right up around Thanksgiving time frame. And what we've been able to do is work very closely with VetraSpec and with the VA's D2D IT team in submitting claims, and in this case, they are original, fully developed claims, meaning this veteran has never ever filed a claim before with the VA for disability compensation benefits. Pension is not included in this. Again, very similar to e-benefits right now, where all you can submit electronically is currently disability compensation claims. Pension has not been included yet. Same way with D2D. Pension will not be included when it first gets fully implemented. It will be restricted to compensation claims. So right now we are testing the original disability compensation claims on a 526EZ, and there have been a number of stumbling blocks. Some of them have been size limitations that were originally communicated, ended up not being that, meaning that originally it was supposed to be 5 megabytes for each file size, like an attachment or so forth. That ended up being 3 megabytes, so the VA is having to go back in and recode and correct that. One of the biggest issues has been with what we call identity matching, and that is when we're submitting this claim and we get a corporate file established and then we try to get the e-folder established, the identities are not matching up with what's already been established in that corporate file. So it's causing errors. So there's a number of errors that are still happening, but those errors aside and working through them directly with the VA, we've been able to get, so far since Thanksgiving, 7 claims successfully submitted electronically through the D2D gateway to the VA. And when I say D2D gateway, those of you out there that have seen this diagram before in some of our other training sessions will recognize this. Those of you who are new, this may be the first time you're seeing this diagram, and essentially this is just the basic mapping of what D2D is. It's literally using the VSO's claims management system, in our case, VetraSpec, to complete our claims, as all of you are doing out there now, and you're submitting them electronically and they're coming into TDVA's claim office. Then what's happening at that point is at TDVA's claims office, we are then taking those claims that fit the criteria of an original claim and are able to be submitted through the D2D gateway, and we are submitting them through that gateway to the VA completely electronically in this testing process. So in this diagram, you can see where it essentially will be submitted from our end through that electronic gateway. That takes care of all the validation and determining if everything's good. And if it's good, it says returns a successful message to us. If it's not, it returns an error message to us. Currently, right now, those error messages are coming to VetraSpec, our vendor. Once we get through a lot of these still remaining errors and problems and this gets opened up, we'll start to be able to see what those errors are as opposed to having to always contact VetraSpec with that. So ultimately, it gets in the VA's regional office here or where it's going to be handled, and it's an electronic claim now to be processed, not having to make paper at all out of it at this point. So it's been a long road. Many of you that have been with us since the announcement of D2D being implemented as far as a process to be set up, and then as TDVA being selected as one of the 9 pilots, we're a year and a half into this already with the development and testing phase, and getting closer. The VA's goal is by the end of this year to be able to actually, or I should say not this year, by the end of this month, January, to have these initial problems that are still remaining corrected, be able to open this up so that we can submit more claims on a larger volume basis that meets the criteria. They're going to be doing just like with e-benefits. They're going to be doing various releases and improving upon the capabilities of this system a little bit at a time, meaning the first release that we're in can only accept an original claim, and that be never filed before. Second release is looking at expanding that capability to go into a supplemental claim or a secondary claim that you've already got the veteran that's filed before. Now they want to file for another issue. They'll be able to do that through the D2D gateway. And then you'll see other releases come out that slowly add forms that can be used, get into a reopen claim that can be submitted, a reconsideration, and so forth, then eventually into pension. So it is going to be, again, a slow process of it expanding its capabilities, but we are looking forward to at least getting into that point where we can open up and submit more original claims via D2D once we get a few more of these problems worked out. Key thing on here, and I'm going to, bear with me a second. Key thing I want to mention on here is when these forms are submitted, any attachments, I should say, the supporting documents, they need to be in PDF format. So another reminder that keep everything you load into VetraSpec in PDF. Please don't load supporting documents for a veteran's claim. Please don't load them into the Documents tab as a image file. So whether it's JPEG or GIF or whatever else, please don't scan it and upload it in that format. VetraSpec can accept that format, but the problem is when those supporting documents get attached to the claim and we want to submit that through the D2D gateway, they're going to get rejected because they're not in a PDF format. So please keep that in mind when you are putting documents into VetraSpec that are supporting this veteran's claim. As I mentioned, our first successful submission was on the 9th of December. That was TDVA having that first successful submission of a compensation claim. That, and again, we were the first of the pilots to do this. There are 9 pilots, VSO organizations, Georgia, Tennessee, VFW, so forth, in this initial testing. We were the first one to be able, through VetraSpec, to get a successful submission of a original claim. Now, that in some cases may not sound like a big deal, but essentially there's a lot of things that have to come together, as I was describing, to make up an original claim. One of those key things is that 526EZ has to be completely filled out, has to be correct. There can't be blank boxes. There can't be something that says of record, of file. There can't be a missing date for VA Medical Center if there's records residing there. So example, you put in there VA Medical Center Nashville. If you don't put any date time frame there, that is going to get kicked back. You must have dates where the time frame pertaining to the issues at hand on the claim is where the veteran was treated for. So VA Medical Center, and they were treated for, I'll use Roger's famous one here, Epizootie. Well, what's the time frame they were treated for that? And you may not know the exact, or the veteran may not remember the exact dates, but if you know that if that veteran says, hey, I was treated at least between January of 2014 and December of 2014, then put January 1, 2014 through December 1, 2014 as the ending date. Put those dates in there. That gives the range for them to make the request, and it allows that document to get accepted electronically. So that's part of everything going in to make it a successful submission electronically, that all the claim forms are completely filled out with accurate information, dates, everything of that nature. So please keep that in mind when you are filling these claim forms out, especially in retrospect, that you are filling all of the information in. Now, as we go through the testing here for the rest of this month, again, we're trying to identify more original claims that are coming in via retrospect that we can submit through the D2D gateway. As we're doing that, we may identify some claims that are just about there, but there's missing something in one of the blocks or whatever else. I just want to let you know that if we know what that information is, we're going to fill it in. If we don't, we're going to attempt to contact you and find that information out. That contact can be through an email or a call, and it may be from one of our claims specialists at the claims office asking to get that information. And the reason for that is because we need to get that filled out so that we can try to use this as part of the test format. So please help us out on that aspect. All right. Hopefully that should bring most everyone back up to date on the D2D. And as more information comes out, I will release that to everyone with some email updates, especially as we make some larger breakthroughs to opening this up for more claims to be submitted through D2D. Before we go into our next scheduled and last scheduled break here, I'd like to end with one particular question that was sent in our first break, and that was in regards to a question about the automated burial payment. That automated burial payment, there was a question submitted saying that there is a spouse of record listed on as a dependent for the veteran and still married, but the daughter actually paid for the funeral. However, first notification of death was made and spouse of record was verified and the spouse received the automated burial payment. That is the way the automated burial process goes. The spouse is the primary designee if they're of record and the legitimate spouse. They will receive the automated payment, irregardless of who else paid any type of funeral bills. The spouse will receive it. If there is no spouse of record, spouse is deceased, so forth, there is no spouse of record, then if there is a next of kin, if there is a daughter, a son, if there is a member designated for the executor of the estate, so forth, that made those payments for the burial expenses, then they can file that 530 form and request reimbursement of the burial expenses that they put out up to the limit. Now, again, it's not automated. It won't come automated to you. You must file for it in that case. The only benefactor in the automated payment process right now is the spouse of record. All others must submit their claim for reimbursement of burial or plot. Also with that spouse, they'll receive that automated burial payment, but if there is an entitlement to a plot allowance, the spouse still must file for that as well. It is not included in that automatic payment process. So hopefully that clarifies that. I also responded to that in writing on the chat box, so hopefully the person that asked that, you received that as well. All right, let's take a 10-minute break. It is about 5 minutes after 10, so at 10:15, this is Central Time, quarter after the hour. Let's reconvene. Again, no need to log off or anything else. I am going to go ahead and just close out the video temporarily and the audio. So in about 10 minutes, I'll come back on and we will start with unreimbursed medical expenses and then finish off with income reporting. One of the questions that was submitted actually, again, was on the burial benefits, and it had to do with what is being stated in the Federal Benefits Handbook that the VA provides, as well as DOD out there, and that it is covering burial benefits and states that those who bore the cost, such as a service-connected death, would be the ones reimbursed. And I do understand this is what that Federal Benefits Handbook states. One key thing to remember here, Federal Benefits Handbook is not law. It is a guidebook of benefits available. It does not state verbatim what law is, and it necessarily does not always reflect current changes to the CFR. And so, remember, the burial law was drastically revised as of July 7, 2014. And in that revision, that is where you had the automated payment process that came into play. And that automated payment process, based upon first notification of death to the VA, does state that the spouse is the primary consideree, the first in line to receive payment, and that spouse will receive the payment automated, process-wise, right, without having the burden of filing a 530 for that burial reimbursement. It also extends to that spouse basically the consideration of not providing that burden of proof that they bore the cost directly of a funeral. It's giving essentially the benefit of the doubt. And what it is it's VA's attempt to provide money quicker into the hands of that now widow to cover expenses dealing with the veteran's death, with that funeral. As such, in that revision, the VA essentially is saying all others are lower on the totem pole, and if a spouse is to be considered and receives the automated payment, it is not the VA's responsibility to divvy that up or address anyone else. They are looking at providing the money to the spouse in that quick manner. It will be the spouse and any other family members who bore a cost to settle up between themselves. So the original question going back with the daughter involved is there was a legal spouse still involved at time of death, listed on the 686C as a dependent. Therefore, that spouse, once notification of death was made, was entitled to the automated death benefit process. Even though the daughter bore the cost, it must be between the daughter and the spouse to settle that bill between themselves on who gets that money. The VA is going to put it to the spouse. So keep in mind, I understand you're looking at a book that is handed to the general public per se, but remember, that is a guidebook. That is a guideline, and it does not reflect law completely. And so that's why you have to refer to 38 CFR to say this is what law is and this is what will happen. So hopefully that clears a few things up on the automated process. Again, it is not, we're not saying it's a perfect process, and it's still got to be refined some more. And when it comes into play for DIC, that is another part, yes, of the automated process. It will be considered, again, to spouse, but part of that consideration for DIC is this: is the death service-connected or not? If DIC was not held by that veteran for 10 years or longer, the death has to be service-connected. It has to be due to a service-connected disability. If it was non-service-connected, the cause of death was from a non-service-connected disability, and the veteran held his disability rating at 100% less than 10 years, then the spouse is not going to get DIC without proof to show that it was the main contributing cause of death or it was the cause of death, which was a service-connected disability. So that 10-year rule comes into play for that spouse, that widow, to receive DIC in an automated process. So if the veteran held a 100% rating less than 10 years, then what's going to happen is the Pension Management Center is going to request a death certificate before they will start the DIC process. Once they get that death certificate and can verify that it was a service-connected disability that caused this death or was a contributing factor to it, then they'll start the process of a DIC claim. If the veteran held 100% disability rating, D&T, for 10 years or more, then it's going to, the DIC doesn't matter if the veteran got hit by a bus. The widow or the spouse, surviving spouse, is going to be entitled to DIC, and therefore the Pension Management Center can continue forward with the automated process of the DIC claim as well. I believe also one of our social officers from Montgomery County had a veteran in this case and experienced this whole process and said it did work pretty good, especially since it was 10 years or more. But I know there are some out there, and I've seen the questions, that it's been under the 10-year mark, and the Pension Management Center is asking for that death certificate before they move forward with a DIC claim. And they're going to have to, because they're trying to determine if it should be awarded or not. It's not a given because it wasn't 10 years for that veteran holding 100% P&T. Additionally, one last thing on the automated burial process. The spouse who gets awarded the automated payment, in some cases, if it cannot be determined if the death was a result of service-connected disabilities or non-service-connected disabilities, the automated payment's going to come at the lower rate. So in other words, it will come at the non-service-connected rate. If it's determined or it can be shown that the death was a result of a service-connected disability, then a subsequent filing of a 530P would have to be sent in by the spouse to get the difference in the amount of reimbursement, such as the $2,000 for service-connected burial benefit. So there is still a responsibility there to get that difference in money if it is shown that it is service-connected in some cases. And another real quick, before we start to move on, one other question, again, relating to the automated burial and DIC. The 1 year or more for POW veterans, yes. Again, I'm only addressing that 10-year because of the questions that were posed. But by law, with DIC, if the POW is involved here, that 1-year law rule applies as well. But it has to be indicated at the time of notifying of death that this was a POW for 1 year or more, so that you're calling attention to the VA to make sure they see that in the file, that this veteran was a POW 1 year or more. Hopefully that will answer a few of those general questions on that. I know there were some other questions on the automated burial and a couple on DIC. There was also questions regarding reimbursement for travel when there is a treatment sought at a VA medical center, and there is a pending disability claim. It hasn't been decided yet, but it's going to be decided. It does get decided. It is service-connected. Can that veteran get reimbursed for travel for treatment of those service-connected disabilities? The short answer is yes. A follow-up that I will send out is there are some time constraints in there that I've got to make sure I'm aware of before I tell you that nothing else is involved. But the short answer to that is yes. All right, let's take a look at our unreimbursed medical expenses. Now, once again, unreimbursed medical expenses for a majority of you out there will be a refresher, and that's what this is primarily geared to, is just making this a refresher to you, dust off those cobwebs, and remember that this is a key part, especially for our pensioners out there and for the widows who have survivor's pension or death pension. This is a key part in continuing their payments, perhaps an increase to their payments that they are filing at the end of the year. In some cases, this is like their tax return as well. They're getting a refund back of some money owed because of what they've put out of pocket for medical expenses. Those of you who are just coming into a VBR position or CSO position, this is going to be first time new viewing. Some of it may seem a little familiar from conversations you may have had or actually being a party to it, whatever. But this will give you a first look at that unreimbursed medical expense reporting. And this is the time of year where CSOs and VBRs are going to start receiving those pensioners coming in to start submitting those reports for that unreimbursed medical expenses. All right. So you should be seeing our title slide now. And for this, many of you are using the Q&A chat box. And that is good. Please continue at this point to use that for questions related to the topics. Any general questions, again, audio problem or I'm not seeing you or whatever else it may be that are not related to the topics, you can use the regular chat window for. All right, unreimbursed medical expenses. So, back here. Our objectives for this training is going to be to understand what the unreimbursed medical expenses are, learn how we can accurately complete the VA Form 21P 8416, and identify what supporting documents are required or needed in submitting our unreimbursed medical expense report. Some of the common acronyms used when we discuss unreimbursed medical expenses or we talk about pension overall: IVAP, Income for Veterans Administration Purposes; MAPR, Maximum Annual Pension Rate; and UME, Unreimbursed Medical Expenses. more common references to utilize in dealing with unreimbursed medical expenses. Note here also I've included the manual rewrite, M21, which essentially, for those of you who are not familiar, is the VA's policy guide. It's how we conduct business. The CFR is there of what law is. The M21 is there how we're going to implement that law, how we're going to conduct business in the processing of these claims. Overall, for medical expenses, I've given you kind of an overall definition here of medical expenses for the purpose of claiming reimbursement when in receipt of pension. Unreimbursed medical expenses are a key item here that can be used to reduce countable income for pension purposes. That is the key takeaway here, is that you can use these unreimbursed medical expenses to lower your countable income for pension purposes. Another key note on that is that from your pension chart that I had discussed earlier, those unreimbursed medical expenses, they need to be above that 5% limit. So essentially, VA is already giving a 5% buffer there, let's say. Anything above that dollar amount there is what you can start using to lower that countable income. And for many of your surviving spouses out there, veterans, they will have Medicare premiums. And that alone, in most cases, is substantial enough to bring them into the pension income rate limits to qualify, let alone other expenses that they would have that have not been reimbursed for medical. Key parts here that within this definition, if the expense was paid during 12-month annualization period. And what do we mean by a 12-month annualization period? Essentially, we're saying that 12-month annualization period is from the date that I'm applying for this pension, or my pension started, 12 months forward. So it may not necessarily be a calendar year. You may not be starting January 1. You may not be applying on that January 1 and going to 12 months. You could be coming in and starting in February, March, whatever. So your 12-month annualization period is based on that rolling 12 months. The date that you began your pension or applying for it, the effective date, 12 months out. So as a result, you're looking at the medical expenses that you paid out of pocket that you did not get reimbursed for, and that reimbursement could have come through another insurance plan that you had or through some other means that reimbursed you for that cost. If you didn't get reimbursed for it, and you paid that out of pocket, and it was a qualifying medical expense, which we'll touch on in a little bit, and it was during your 12-month annualization period, then you'll be able to claim that and reduce your countable income. Now, let's say that expense, that medical expense, let's say you incurred that medical expense, it was billed to you, let's say, not within your 12-month annualization period, but you actually paid out of your pocket. You paid the money, by check, whatever, to the medical provider who was billing you for that service, and you paid for it within that 12-month annualization period of your pension benefit. If you put the money out of your pocket during that 12-month annualization period, but you were billed for it or the services were rendered prior to that, you can still exclude that from, or count that as an unreimbursed medical expense and use it to reduce your income because it was with, you actually put the money out during that 12-month annualization period. So sometimes you'll have, especially a new pensioner come in, and while the service they received was prior to when they are applying for pension, they may be paying it later on, and if their effective date of pension establishes their 12-month annualization period, during the time frame they paid that money, then they'll be able to use that as an unreimbursed medical expense. All right. Let's look at unreimbursed medical expenses that can be claimed. You can claim expenses paid by yourself or surviving spouse. You can claim them for yourself, for children. So you have your dependent children, you can claim that deductible medical expense or that you paid out. For dependent parents, again, I'm going to stress dependent parents. Other relatives that you have a moral or legal obligation to support. So you may have a cousin or another relative that you have a legal obligation, let's say, or even there is a moral obligation to provide support for them, and you're helping them with their medical needs and so forth. That can be an expense that you also included in your unreimbursed medical expenses. Say a person who is a constructive member of the household. By constructive member, we're saying a contributing member of the household, and they may have income that's coming in, but they're an active part of that household. So you can use any unreimbursed medical expenses you have that you paid out of pocket for them as well to deduct from your countable income. We mentioned previously about that 5% of MAPR in order to reduce your income for VA purposes. So from your pension rate chart, you're going to have a column over there that lists the 5% MAPR. Basically, it says, here's my dollar amount, and in this case, let's just take a veteran alone, not a spouse, but a veteran alone. Veteran alone has a $643 5% MAPR. So essentially, everything above that $643 that is legitimate unreimbursed medical expenses can be used to help reduce that veteran's countable income so that we can establish an income for VA purposes and perhaps qualify them for pension or continue them on the pension rolls. So in a very simple type of example, if you had a veteran that essentially has a medical expense for Medicare alone, $104.90 per month, Social Security, so they got $1,258.80 in unreimbursed medical expense. They're paying that out of pocket, being deducted from their Social Security check. That alone is going to be able to be applied in that excess of that $643 to help reduce their income. So there's a number of other things out there that most veterans are going to have as a medical expense they've incurred. And with that, that can help reduce their income for countable purposes to get them to qualify for a pension. Remember, our threshold limit is very low on the veteran alone. And you're looking for all of those deductions that you can make. So unreimbursed medical expenses can be a large part of that contributing factor to get that income threshold down. They have to be actually paid medical expenses by the beneficiary. In this case, if we're talking about the veteran, or the widow, surviving spouse, if it's a death pension. And with no reimbursement received, as I mentioned before, from insurance or another source. Continual medical expenses, key thing here. If this is a one-off medical expense, one of the things you have to be very careful about is expenses that are not reoccurring or not continual, that you claim this, but yet, hey, this is going to stop midway through my 12-month annualization period. So you may be taking, you know, a certain antibiotic that is expensive, but it's only going to last for a short period of time, maybe 2 months, 3 months, whatever. That, if you're going to claim that, you have to be careful, because that amount, when it stops, you no longer pay for that particular drug. If it's still within your 12-month annualization period, that could impact you on your countable income to the point of you may be over the limit. Not always that will happen, but if you're very close as far as qualifying for a pension, small adjustments in those medical expenses can impact whether you continue on the pension rolls or not, or are eligible. So you do have to be careful about counting anything that is not a reoccurring or continuing. Over-the-counter medications, I know most of you are thinking of that probably right off the bat. The VA allows over-the-counter medications to be counted up to a $500 limit without receipts. Over that amount per individual, such as a veteran or dependent child, so forth, you have to have those receipts to support it. But under that 500 and under, you can claim that as an OTC, over-the-counter medication that's used. VA is saying we recognize during that 12-month period there are various over-the-counter medications, whether it be sinus medications, cough syrup, so forth, that you're probably using that impact you're not getting reimbursed for. So they allow that type. But continuing medical expenses, some of those examples such as nursing home expenses, and again, the Medicare deduction, your medical insurance. You may have a veteran out there that carries additional medical insurance. They carry Blue Cross Blue Shield, Cigna, whatever. Or they're on their spouse's plan. Well, that premium's coming out, at least out of their spouse's paycheck. It's a burden on their household income. That's a legitimate expense to claim as well. As well as mileage. Mileage to and from the medical provider and place of residence for the veteran can be deducted. And we'll cover that in the example of the 8416 that I have here. Some additional continuing medical expenses, in-home medical care expenses. And as I've noted on here, if you're rated, the veteran was rated for A&A, aid and attendance, or housebound, you can deduct those wages from the attendant who provides medical or nursing services within the house. Additionally, if the veteran was not rated, or in this case, the surviving spouse was not rated for A&A, aid and attendance, or housebound, you can still deduct those wages for that in-home attendant, but there is a stipulation that it has to be a licensed healthcare professional that's doing the work. Unlike the previous bullet, that attendant does not necessarily have to be a licensed healthcare professional. If they're rated A&A or housebound, you know, it could be a family member that's providing that in-home attendant care. And the last bullet there, same applies for adult daycare. Notice I'm specifically saying adult daycare facility. I'm not saying a nursing home here. That same requirement applies as far as a licensed healthcare professional administering that care in order to deduct that attendant cost. All right, so our 21P8416 medical expense report. We use this form to be able to list all of those unreimbursed medical expenses that we are claiming, submitted into the VA to get that reimbursement, basically an adjustment to your pension payment. And what it does is, as I mentioned earlier, it's sort of like another tax return or refund at the end of the year. Because in most cases, this is going to provide some additional money back in the pockets of the veteran or the widow, because the expenses that they put out of pocket, had they been accounted for during the 12-month annualization period every month, and the VA just included that in the pension payment, then that additional money would have been in the veteran's hands already. But since it was not, then the VA is coming back and saying, okay, this is the difference for over that 12-month annualization period that we owe you as far as your pension payment. And it's a little retro check, again, like a tax refund. The thing you have to be careful about when we do this form is when you look at, because you can also submit to the VA a projection. And that projection can be, you can say, well, I project these expenses to be the same for next year and would like that adjustment made to continue on for my next 12-month annualization period. If you do that, and the VA goes ahead and makes that adjustment, and something happens during your next 12-month annualization period that you don't meet that same amount of unreimbursed medical expenses, then at the end of the year, when you're filing this report again, and it comes up less, you're going to be in a situation of an overpayment, the veteran would be. And therefore, the VA is going to be asking for some money back. So I just want to stress here, be very careful when you are considering projections for your veteran or the widow, because it can come back to haunt them the following year. And that's the bitter pill here. You don't want to end up a year later telling the veteran, oh, we probably shouldn't have done that, or that changed, so now unfortunately you owe some money back instead of expecting money coming from the VA. So be very careful in projections when you're doing this. But for this form, when you're doing the current 12-month annualization period, you'll notice the first page of it. And those using VetraSpec, I will call note, yes, this first page of instructions is not included in the form. But on the VA.gov website for VA forms, everything, the instruction sheet is included in there because this is available to everyone to download and utilize. But in our example here, we again want to make sure that all information is filled in, and those of you, again, using VetraSpec, our claims management system, once you fill that profile out for that veteran or that dependent, that spouse in VetraSpec, that general information is going to carry over here. But you want to make sure all of the information is filled in. In the case of a veteran, we want to make sure that VA file number is here, as well as their Social Security number. In a number of cases, it's going to be the same, but in some cases, depending upon how long the veteran has been in receipt of benefit, how far back that initial claim goes, they may have a C file number or a different VA file number than their Social Security number. So you want to make sure both are filled in, all of their pertinent information on address, phone number, so forth, and email address if they use email. If they don't use email or they only check their email once a month, it may not be beneficial to have that there. When you get into the itemization of expenses on the first page, we want to include the dates. Now, for this example, I did include, just for simplicity purposes, 1/1/2014 through 12/31/2014. These are the dates you're including these expenses for, that 12-month period. The first page here will be considering your mileage expenses. So on your mileage expenses, let me a second. On your mileage expenses, you'll list the facility that you've traveled to. So in this first example, you'll see we have Dr. White's office, and then the address, city and state. The total round-trip miles. Again, this is round-trip miles, and notice that it says personal conveyance only. Okay? Again, this is your vehicle, or I know there's going to be some questions right off the top of your head I can see. What if my neighbor, my daughter, anybody else is using their vehicle and I'm riding it? Okay, it's a personal conveyance vehicle. You go ahead, submit the claim as if it's, you're in your vehicle traveling. It's a personal conveyance. They're taking you. The mileage reimbursement that you're entitled to, you and that person that's taking you with their vehicle can settle up how you want to settle up. But that reimbursement is still an entitlement to you, the veteran or the spouse, for that. The next column, the C column here, says amount paid by you, but it will say taxi, public transportation, parking fares, parking tolls, so forth. So if you take a taxi to that doctor's office and you pay out of pocket that full amount for that cab fare, for that ride to the doctor's office, then that's a full expense here. It's not a mileage, it's a full dollar expense that you would include here. And then the date that you made that payment is going to be listed here, and who it's paid for. So in this case, because we're dealing with a veteran, it's going to be self. And then for any other facilities that you're traveling to for your medical care, right, you would list those down here in subsequent fields, and what that mileage is, or, as I mentioned before, what that taxi or public transportation fare was for you, and then the date you paid it. Now, as we complete the mileage portion, then we get onto the second page here, and again, making sure our dates for our time period are filled in at the top. Now we get into those actual medical expenses. These are the expenses, and you notice that Medicare Part B will already be filled in. And Medicare Part D. So here, if you have expenses for that, you would list that expense. And in this case, date paid, again, it's a month, day, year, but we have summed the whole total up and just put the end of the year date in there. Provide, in this case, Social Security, it was deducted out of, and again for ourselves. If you have a Part D, what that amount is, and again, the sum for the year, last paid out of, and who that went to. If there was private medical insurance, like we mentioned before, could be Blue Cross, could be Cigna, Humana, any of those out there, then you would list that premium there and the last date paid for the year for that total premium, and then who that is, that provider was. Then we get into areas that you start filling in related to medical expenses, whether it be prescriptions or emergency room care or doctor's visits, over-the-counter medication. You can see by the various examples here of the different ones you can put in here. Now, same thing, the amount you paid for that 12-month period, or the last date you paid, or if this was just a one-time, that $120 one time, the actual date you paid it. Who it went to, and again, if it was for yourself, spouse, and a parent, child, contributing member of the household, whoever, that you would be entitled to claim that expense against. And at the end, once you have filled in all this information of what their unreimbursed medical expense is, please make sure that you have the signature done. There have been a number of times where this form gets submitted, and especially by mail, the time it takes, through the mail, gets in to the pension management centers, it gets processed, starts to get processed, and all of a sudden, the notification gets sent back to the claimant. There's no signature on this form. They need that signature before they can go ahead and process it. So there have been many times that I've seen that that signature was not put on there. So please make sure that your veteran or spouse or whatever is signing that form before it gets sent in. I see a quick question that when we were addressing mileage, it looks like there was a question out there about trips to the pharmacy. Can that be done for mileage expense on there? Okay. So here's the short answer to that is if you're going to the pharmacy to pick up prescription medication that you're taking, yes, on a regular basis, yes, you could put that mileage on there because it is in the care of your health. It is a regular, reoccurring trip that you must make in order to maintain your health. So you can justify it in that aspect if asked to. So, but you want to make sure we're not just trying to do this for the sake of, I got 5 miles one time trying to do it, that there are a number of times out here that you have to go. Another key point, or one of the questions / points that someone just sent in out there, and that is absolutely right. Also makes a good segue for me. I'm going to identify in many ways. Thanks, Alex. That was my next point on here too. Is on this signature block, remember that this is the claimant that needs to sign, not you, the veteran's representative, the accredited representative. Keep in mind, all things financial for that veteran and the original claim, okay, must be signed by that claimant, not by you as a representative. This 8416 is a financial form. It is stating these are the expenses I, the veteran or claimant, have paid out of pocket, and I want reimbursement for it. Therefore, it is a financial form, and the veteran or claimant must sign it, not you, the representative. So, Alex, thanks for that, helping me into that segue, and very good point on that. All right, another key point here on our expenses, no time limit to submit the report in order to reduce, I'm going to stress this, reduce or eliminate overpayment per reporting period. And why I'm stressing those key areas is this. For submitting an 8416, if you have expenses for unreimbursed medical expenses, if you're trying to eliminate or reduce an overpayment, okay, you can submit an 8416 that may be a year old. It may be a year into when this overpayment was later determined. So an example is you get all the way almost to the end of 2015 or you get to 2016, and all of a sudden you get a notification from the VA of an overpayment for 2014 based on income verification. Well, when you go through this and you look at your unreimbursed medical expenses, okay, and you have unreimbursed medical expenses that you see probably were not reported or may have been overlooked if you did report them, and they occurred in 2014, that would have not had you in an overpayment status or would have reduced the amount of overpayment the VA is saying you have, you can submit that even though it's 2016 because those expenses occurred in that 12-month annualization period that the VA is saying an overpayment happened. And since you're attempting to reduce or eliminate this overpayment, there's not a time limit for you to submit that 8416. So that can happen. All right. Let's do a little kind of quick quiz in here. And for this, we're going to utilize some of our little icons there in the participant panel. So earlier in this, when we started the webinar, I brought everybody's attention to the nice little raise your hand. Okay. Well, next to raise your hand, there's a little check mark, and there's a little X, red X, those little icons there in the panelist panel. If you click on one of those, it goes next to your name, and it signifies for a check mark, it signifies yes answer, and an X signifies a no answer. So again, this is just kind of getting a gauge of how many people think yay or nay for each of these little review questions. Right? So for the first question, fees charged by an approved nursing home in which the claimant is a patient. Is that a yes or no? Can it be used as a deduction? An unreimbursed medical expense to deduct income. Yeah, getting a few of you out there that hitting those check marks. Yeah, good. All right. Good. So we got a large majority of everybody that has responded here. You hit your check mark saying yes, it can be used or might be used as a deduction from countable income, which is correct. All right. Let's go to the second question. And same thing. If you agree, use your check mark. Those of you who left your check mark up there, you don't have to click on it again or take it down. You can just leave it there. But if you're changing your answer, then click on it, take it down, and put your X up there. Number 2, fees charged by an in-home attendant. Might this be used as a deduction for countable income? Yes or no? Okay, yeah, most of you are leaving your check marks up there, I think. Good. So yes, but here's a subsequent, and you don't have to answer on this, but there is a situation when it would be no, and that situation when it could be no is, again, if the in-home attendant was not a licensed healthcare professional and the individual was not rated at A&A or housebound. So if that situation applied, then you would have to say no to that one. Okay. Number 3, premiums paid by the claimant for health, medical, or hospitalization insurance. Might this expense be used as a deduction for countable income or not? Yes or no? And again, if you agree, go ahead and leave your check mark up there. If you disagree, change that out for an X. Okay. Again, majority of you all saying yes to that, which is good. It is yes. You can use those premiums paid by for health, medical, or hospitalization insurance. Remember, the Medicare one is the simplest one. Remember, on the 8416, the block there for private health care insurance. If you had a Blue Cross, Blue Shield, or a Cigna, or Humana, United Healthcare, any of those, if you were paying that premium, you could use that as a medical expense, unreimbursed medical expense deduction towards your countable income. All right, number 4 is a $500 for a chiropractic treatment of your lower back condition. Could you possibly use that as a deduction from countable income? Yeah, once again, seeing the majority out there leaving up their check mark signifying yes, which is correct. With a listing of allowable deductions, medical expense deductions, the chiropractic care can be used for those deductions. And I just threw this sheet up here, which was one of the handouts you should have. But chiropractic care can be used as a deduction on there as well. Right? So if you look right over here, you have chiropractor right there that can be used. Okay. All right, question number 5. Mechanical and electronic devices used to compensate for the claimant's disabilities. Could you use this as a deduction from the countable income as an unreimbursed medical expense? Again, if you agree, you say yes, leave your check mark up. If you say no, change it out. Okay, and once again, the majority of ours answering out there is yes as well. And then our last one should be an easy one too, based on 8416. Bus fare paid to go from home to a weekly physical therapy session. Could that be used or not? Okay, once again, majority of you agreeing that yes, you could use that. Public conveyance, public transportation, you're paying that money out of your pocket for that transportation, and it was all paid at once during that particular bus fare. For treatment, again, this is physical therapy due to an injury or whatever that you had. So good. Again, this is just a nice short review of kind of what we've covered about reimbursement expenses. The list that I shown earlier, this is not an all-inclusive list, so it is always subject to change. There is at some time, from time to time, there may be some medical expenses not listed on here that come into question that may be able to be claimed. So when in doubt, look at if it seems to be legitimate for treatment of a medical condition, then claim it. You know, the VA ultimately will ask for clarifications and make that final determination. But if you don't, then you may be cheating your veteran or that widow, that claimant, out of some money due back to them. So just remember, this list is not all inclusive. All right. Now, I've seen a few, and I've tried to highlight a couple of them, and I know Lee has been trying to respond for me too on a few of the questions that have come in while we've been covering through this. But at this point, I'd like anybody else, if you've got some additional questions on unreimbursed medical expenses, go ahead and type those in. And we'll see if we can answer those. So I'm going to give everybody about 3 minutes here to do that. And so I'm going to pause for just a moment, see if there's any other remaining questions, and then we'll try to address a few of those, and then cover our last topic, which is financial status reporting. All right, income reporting. So the use of 1010 EGR 5655. And for this, we want to focus on understanding when that income reporting should be done. Also, how to complete that 1010 EGR if using that for VHA sign, or a 5655 if using that form. And then again, also identify what supporting documents may be required. Once again, our references that can be utilized. And again, you will see I'm citing also the M21 and the manual rewrite. Again, the VA's process there, how they're going to do business, is the manual rewrite in M21. So our 1010 EZR, with our 1010 EZR, we're going to use that to report again the income that can impact the eligibility for your continual enrollment in VA healthcare system. Once again, income verification reporting is being done through Social Security and IRS, but you have to consider other outside sources, other things that impact, such as inheritance, lottery winning, and so forth, that lottery winning and so forth, that could impact at the time of winning it. And so you can use this form to notify the VA earlier on of those changes in your income, or as well any changes in address and information, personal information. And then as of March 2014, mentioned earlier, the 1010 EZR was no longer required to be submitted annually, such as the annual means test. The means test for VHA is still required up front when initially applying. The veteran, again, can elect not to provide the financial information, as the VA states. However, it can slow the process of them making the determination. But annually, once they are enrolled, they no longer need to submit this. They won't send this form automatically either. But if there is a significant change that they want to communicate to the VA, because ultimately what happens if you don't notify them, the VA finds out, and 2 years, 3 years, 4 years after the fact, you're getting a notification of medical debt, then you're going to have to deal with how am I going to repay that medical debt, or fighting to get a waiver of it, and so forth. Where if you notified them earlier on, you would have the ability to say, I made my notification, I did my due diligence in it, and you could have more ammunition in fighting for that to be waived if they were still requiring it. So our 1010 EZR, let's take a look at that form. Again, because the regular use of it is not out there since March, many of us may not be as familiar with it, but it still exists, still there in VetraSpec as well for those of us using VetraSpec. Using our famous veteran again, Donald Duck. Again, general information that will be carried over from the profile, but you want to make sure this information is carried over and filled in. Especially relationship information, next of kin, emergency contacts, make sure that is filled in. And again, this form can be used for any of this information that changes. You could have a relationship change, or next of kin change, let's say, or emergency contact change, and you're just submitting this form to notify the VA of that change only. This can be done for that. And coming back down here, again, in section 2 here, insurance, make sure this is not left blank. The number of times when this form is used and submitted, either one is checked. They're going to require, say, yes or no. They want to know if there's additional health insurance out there, either from a spouse, another person, or so forth, that is covering you as a beneficiary in some manner. Are you eligible for Medicaid? Again, make sure you're answering that, yes or no. If yes, what those effective dates are. All right? When you get into the next page, you're going to have dependent information, if it applies. And then you'll start to get into income information. Again, some of this may seem a little familiar as far as the layout goes. when you're working with a 534, EG, your veteran spouse, child, so any income that can impact the eligibility, the household income listed there. In this particular case, we're listing the Social Security income here, or any other type of income from both the spouse and the veteran. And any non-reimbursed medical expenses they incurred at the time of submitting this report. And then down here, cash or amount in bank accounts, savings, checking, certificate deposits, so forth on hand. Once that's completed, again, even if this is just an informational only change, is to say I've got a change in my next of kin or so forth, it's still considered a financial status reporting form. Therefore, you've got to make sure that it's the applicant, it's the claimant here, the veteran, whatever, that is signing, not you, the representative, that is signing this form. Okay, just on the 1010 EZR, what are some of your questions you may have on that? Let's take a look at what have been submitted. I've got one question out there that says, looks like 2 years ago we were told not to do the EVRs and 8416 if their medical expenses had not changed by $800. Is that still the case, or are we to do all of them again? Okay, so EVRs, as I was just saying on here, the annual means test for EVRs, whether it's the pensioners, just taking that side of the house, or VA healthcare side, is not a requirement to be filled out. Right? What this financial status reporting on the 1010 EZR is to notify if there's a significant change, notify the VA up front so that you can identify any potential overpayment and hopefully avoid that from hitting you 2 years down the road or 3 years down the road when the VA does an audit and says, oh, we paid you too much, or you owe for these medical co-payments because you should have been paying them based on your income at this point. So while it's not a requirement annually to do, it still is, if those significant changes happen, you should submit that information. Now, the $800 amount, again, getting in and defining specific dollar amounts can be a little dangerous, because what is $800 for one particular veteran situation may be substantial and impact their eligibility based on the income. For another veteran, it may not be. So again, you want to look at, is it a substantial amount that could impact it based on what their income is right now? And if so, then go ahead and report it. Because ultimately, if the VA fails in a timely manner to address the this, then you've done your due diligence, and you can have this as ammunition in saying, that is not my fault. I notified you in a timely manner that this is a situation. You did not respond in a timely manner. Therefore, I should be waived from this debt. It helps in that argument, not saying it's not going to happen, but it helps in that if you worked up front in a timely manner. All right. There's a few other questions. I know Lee is responding to some of those. I will, let's do the last part of 5655 because we are nearing the end here. And I know it's been a long morning and there's a number of things that everybody else has to do. So let's kind of quickly cover our 5655. 5655, right here, 5655, this form, remember we use this to determine A, eligibility for waiver of collection of debt that you owe to the government. So you could have a debt due to overpayment for pension benefit, a debt for payment on the compensation side, debt for medical co-payment debt, for a number of different reasons as far as was paid to you and owed to the federal government. This 5655 income reporting form can be used to request a waiver of that collection of debt, can be used to do a compromise offer, because if the debt is legitimate and you agree it's legitimate, you could use this to help support a compromise offer, basically saying to the VA, if I was to pay this much right now, would you waive the rest of the remaining debt completely? And here is my income and my expenses and so forth, so this is what I could afford to do, and I'm asking for the rest to be waived. A compromise offer. So this 5655 can be used for that. It can also be used for supporting hardship, financial hardship cases. So you may have a veteran out there that is filed for disability compensation or pension. They are in extreme financial hardship, and a decision on that claim, if it's awarded, is going to provide some financial relief to them. But having that decision take almost a year is not going to be helpful enough to them. So you can use this 5655 to help support the request for expediting that claim due to financial hardship. And this form will list all of their income and expenses, and you'll use supporting documentation such as maybe a foreclosure notice on their house or a number of collection notices for different debts that are out there that they're basically unable to pay. The 5655 can be used to help support that entire request for it. When we look at this form, an example of it, again, making sure all your information is filled out. And in retrospect, again, the profile information will carry over, but you still want to make sure that everything is correctly filled out. Employment information, you'll notice, is asked on this, okay? And if you look, again, yourself and your spouse, if that applies, for the past 2 years is what it's asking you here. Additionally, when you get down to Section 2, we talk about income, and Section 3, expenses. So you'll have average monthly income, yourself and spouse of each of the categories. And then you're going to have expenses that you're putting out, such as rent, mortgage, food, utilities, and heat. And then other living expenses, like life and auto insurance I have listed here. Those will be listed. And then here, this line 22 is going to be a carryover from what you're going to see next from other line items, so that it can total out what your expenses are. Okay, and then there's a calculation that will come about that will say this is what your net monthly income less expenses is. So it'll list that on there, and then line 24 essentially is what you're saying you can afford to apply towards your debt. So if you were doing a compromise offer, you'd be making an amount in there to say you're willing to pay right now. And then your additional information such as cash in bank, cash on hand, automobiles, savings bonds, and then other debts that you may have. You may have personal loans out there, card loans, credit card debt, again, medical debt over here that's being collected on, that there's actually contracts to collect on. That'll be listed here. And if you've ever declared bankruptcy, that information if you have. And then at the end, appropriate signatures. Remember, if the spouse is involved here, you're married, spouse is here, that income's being applied, you got to have the spouse's signature on here as well. So veteran signature, spouse's signature. Again, this is a financial form. Must be their signature, that veteran's signature or that claimant's signature, not your signature as the accredited representative. So to kind of sum up on our income reporting, again, looking at understanding the income reporting, how it should be done, learning to fill in our 1010 EZR if we're using that form, and the VA Form 5655. Again, the 1010 EZR, no, not required on an annual basis to submit, but if there is a substantial change in income or there is change in address, change in next of kin, emergency contacts, that the VHA side, the healthcare side, needs to be made aware of. The 1010 EZR is the form to use for that and will be sent in. Okay, give a couple minutes here just so we can address maybe one or two questions, and then we will wrap this session up. Remaining questions, we'll look at submitting those out to those individuals via email. And there were questions also submitted in during our break about D2D. Those documentations from the slides that I have, that information, I will send that out in an email as well to everyone. That was recent information as of a call I had this week. So I put that together actually last night so that we could have a more updated version of that. But I will send that out to the field as well. There. So let's just take a minute or two here and we'll address one or two questions. So I'm going to pause for a moment and be right back and look at one or two questions and then try to address that. Through some of these questions on the 1010 EZR. One of the questions I'm going to address here, and Lee again is responding to a few other ones, but one I'd like to address at the end here of the webinar was one submitted about bankruptcy, and it was dealing with the, try to pull that 1010 EZR back up for us. Give me just a minute. So on the 1010 EZR, the question was regarding a bankruptcy. If it was a pending bankruptcy, tell the time when it's coming up there.
11:38.
I'm sorry, I was saying it was 1010 and I'm mistaken. It's 56:55. This was dealing with bankruptcy, and they want to know if it was a pending bankruptcy, if it had to be listed as a pending bankruptcy. Now, one of the key things on the bankruptcy question with the 5655, and while my form catches up. One of the key factors on this is that the form, if a bankruptcy is involved, it is asking, is a mortgage company or a VA loan involved in that bankruptcy? And if so, then they're wanting additional documentation submitted And the key thing, though, is they're asking if you've been adjudicated for bankruptcy and if it has been, what's the discharge date on there. So in a pending status, no determination has been made yet. You don't have any official determination on it yet. So whether you're being relieved from that debt or you'll be required to make some of those payments under that bankruptcy requirement is yet to be determined. While it can be a factor in here, it may or may not be. I would be utilizing, in this particular case, since this is something that's pending, I would be utilizing a 4138 to make some details to say that this is a pending bankruptcy, you filed on such date, and here are the circumstances, but no determination has been made of yet. If a determination is made and you are not relieved of all of this debt under the bankruptcy, then it will impact this amount. So a 4138 can help provide some space for additional information about that. All right, well, it is 11:45, so we've gone 15 minutes over, and I apologize for that. A couple of our short pauses in between there just to address some questions, I think, added to that, so I apologize, but I wanted to try to address some of these questions here during our webinar. I hope that each of you found this somewhat beneficial or extremely beneficial. Hopefully it minimized your traveling as well, and I hope also for a lot of you it allowed you to remain in, at least in your office or near your office to do this as opposed to traveling, and still allow us to be able to present this information. I'd like to wish, again, a very happy New Year to all of you, and